Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this question bank series, we'll look at 3 questions in relation to legal causation, which falls under criminal law in FLK2. Let's dive in. Here's the first question we tackle today. During a street fight, a man stabs another person in the chest. The victim is taken to hospital and given antibiotics as part of the treatment. Unknown to everyone, the victim has a rare and severe allergy to the antibiotic, which causes a fatal reaction shortly after it is administered. The allergy was completely unforeseeable, and there were no warning signs in the victim's medical records. The stab wound itself was serious but would not have been fatal without the allergic reaction. Can the prosecution prove that the man legally caused the death? A. No, because the antibiotic was the sole cause of death. B. No, because the allergic reaction was unforeseeable and breaks the chain of causation. C. Yes, because the man had the intention to cause serious harm. D. Yes, because the stab wound was still an operating and substantial cause of death. E. Yes, because any action by the hospital is always part of the chain of causation. You can pause the video and think about it. The best answer is D. Yes, because the stab wound was still an operating and substantial cause of death. The stab wound was the reason the victim was in hospital and receiving treatment. Even though the allergic reaction was rare and unforeseeable, it does not break the chain of causation. The law requires that the defendant's act is a substantial and operating cause of death. For relevant case law, see Smith, 1959, and Cheshire, 1991. The fact that the reaction was unusual or unforeseeable does not absolve the defendant. He must take the victim as he finds him as per case law Blowy, 1975. Legal causation is still established. Let's look at another question very similar to the first question. A man attacks another person with a knife, causing a deep wound to the victim's leg. At hospital, doctors recommend a blood transfusion to save the victim's life. However, the victim strongly refuses the transfusion on religious grounds. As a result, the victim dies from blood loss a few days later. Can the prosecution prove that the man legally caused the death? A. No, because the refusal of medical treatment was the victim's own decision. B. No, because the refusal was unreasonable and breaks the chain of causation. C. Yes, because the stab wound was still an operating and substantial cause of death. D. Yes, because the man had the mens rea for murder. E. No, because the medical team should have overridden the victim's refusal. The best answer is C. Yes, because the stab wound was still an operating and substantial cause of death. The defendant must take the victim as they find them. The victim's refusal of medical treatment, even if based on religious belief, does not break the chain of causation. The wound caused by the defendant remains an operating and substantial cause of death. The death still flows from the original unlawful act, and the law does not allow a victim's personal beliefs to shift the blame away from the attacker. Here is the third tricky question. A man punches a stranger during an argument, causing a broken nose. The injury is painful but not life-threatening. At hospital, a doctor mistakenly injects the victim with the wrong drug at 10 times the recommended dosage, despite clear labeling on the medication and warnings in the victim's records. The injection causes the victim to go into cardiac arrest and die almost immediately. Medical experts confirm that the original injury would not have caused death. Based on the rules of legal causation, who should the prosecution charge with causing the victim's death, and why? A. The attacker, because he started the sequence of events. B. The doctor, because the death was caused by an extraordinary medical mistake. C. The hospital, because it employs the doctor who made the mistake. D. The doctor, because his gross negligence was the independent and dominant cause of death. E. The attacker, because but for the punch, the victim would not have gone to hospital. The best answer is D. The doctor, because his gross negligence was the independent and dominant cause of death. In cases involving medical treatment, the original attacker is not liable for death if the medical error is so extraordinary and independent that it breaks the chain of causation. This principle was established in Jordan, 1956, where grossly negligent medical treatment, including administration of antibiotics the victim was allergic to, against clear instructions, broke the chain of causation. In this scenario, the doctor's action, a tenfold overdose despite obvious warnings, was so serious that it became the new, dominant cause of death. Therefore, legal responsibility shifts to the doctor, not the attacker. Here is the summary of the key legal principles on causation in criminal law where intervening events arise after the defendant's initial act. In the case of an allergic reaction to antibiotics, the thin skull rule applies. The defendant must take the victim as they find them, meaning an unforeseeable medical condition does not break the chain of causation if the original injury remains a substantial cause. Similarly, where a victim refuses medical treatment for religious reasons, the defendant is still liable. The refusal does not break causation because the injury caused by the defendant remains operative. However, in cases of gross medical negligence, such as a fatal overdose, the chain of causation can be broken if the medical error is so independent and extraordinary that it becomes the dominant cause of death. These principles distinguish when liability remains with the original wrongdoer versus when it shifts due to later events. Have you noticed how a slight change in facts, such as the nature of the subsequent intervening events, can lead to a completely different legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE 1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.